maybe it would be a nice kind of discussion up until the time we to adjourn. But it talked about preparation, how much do you prep before you have a mediation? And some of them, most of them prep. And there are about 1 or 2 people who said they did not have an opportunity because they work in the court system. They were not able to have any information before they did the mediation. So I want to kind of, what do you all do? You know, does anybody?
I really believe that not knowing anything is the best way to go. And when we've done cases for Wendy, I like that. I know nothing. So it's so objective.
As far as being prepped on the details of the case, exactly. I don't want to, I want them to share with each other in front of me.
For that, except that we do on our end in the office have some contact with them because we screen them for any kind of concerns like domestic violence or anything like that. Also on other types of cases, for example, in common pleas cases, there's a lot of prep that's done. I talk to the attorneys. I don't talk to the clients first beforehand, but I talk to the attorneys, and if there are issues that are pending, I read those. I want to find out who's going to be there, make sure the correct person's at the table.
In those cases, I think it would be more akin to the types of cases that were part of the study. Because I think the study was specifically for civil mediations with represented parties, mostly in the private context. So I think there was some.
One of the things for the preparation area is that they were also talking about finding out what are people's goals for the mediation. Because most people have as a primary goal is to settle the case. Like, let's just, to settle it. But other goals that came out were to minimize the future time and costs and risk of continued litigation. So it's good to find out what people were actually thinking or retaining. They wanted control. Some of them wanted their underlying interests to be met. Some people just wanted the opportunity to be heard at their day to be able to discuss it. And they also sometimes wanted just feedback from a neutral professional on where their case might be. And that's where another topic of subject matter expertise come in and stuff like that. But the people that were the users liked the idea of having the mediators be more prepared. Mm-hmm. They liked that they would know enough about what's going on. They don't want to pay for you to know too much, like if you're getting reams of information from the other lawyer or whatever. They don't want to change, whatever. But they did want people not necessarily to walk in completely cold. And yet on the other hand, they also don't want to have a preconceived notion of how you think it should play out.
Okay, which that brings you into the segue of mediator subject matter knowledge. What do you think about that? Some people think you have to have experience, background in a particular area in order to handle that mediation. What do you think?
I'm not in favor of saying to do specific kinds of mediation, you need specific kinds of training, except as appropriate. Here's the example I would give. I've been mediating for the post office for about 15, 16 years. They have lingo. They've got all kinds of acronyms and lingo, and you just learn it. You learn it as it goes. But I know, these are personnel disputes. I know what promotion, lack of promotion, termination, letter of discipline in my file. I know what those words mean. So in some cases I see it's appropriate, but I sure wouldn't want that to be a creeping movement where it's more and more background education required.
Place for process expertise, and that's really what they're coming to you for as a mediator. But you need to know enough of the subject matter so that you're not holding them back.
Right. And you know how to ask the right questions, right?
Right.
Because they're asking, right, if it's and what information is still necessary if they don't know. They would know what questions if they can't even answer right there. They would know what types of information they do need.
Yeah, but I think sometimes it can hurt the process if you're too much of an expert, because then you're not looking at it through fresh eyes, you don't ask the right questions. And so my take is always that if there's counsel, they're the legal experts. They should know the law better than you do because this is their area of practice. In the same way that the parties should know the facts better than you do because it's their dispute. So So the lawyer brings the law, the parties bring the facts, and then you bring the mediation process.
But it does kind of help to have a broad knowledge of whatever they're talking about. If you need to kind of expand your thinking, you need to say some things that will get them, maybe questioning the assumptions that are kind of leading them into the conflict, or just thinking about different types of solutions.
Well, we get that in foreclosure all the time. Like if somebody's denied for one type of modification program, unless you've done this before, you wouldn't know to ask, well, maybe did you qualify for FHA AMP or this other type of program? And so having a little bit of subject matter expertise enables you to ask probing questions that you may not have been able to ask otherwise.
So if you have an unrepresented defendant, they have no idea what questions to ask, and a mediator that knows what questions to ask. If the goal is settlement, then the mediator can really bring the parties toward a settlement where one party may not be involved in a settlement option.
It's well said.
Very good point.
Yeah, that's a good point, especially for the power imbalance situations.
I have a question, maybe I don't know how appropriate it is, but in the situation that you just described, where you have one party who is unrepresented and lacking that expertise, even if you didn't have it, do you need to assure that they have it somehow? Is there a way for them to have that expertise available to them, so it's not lost?
I would say probing questions to the other side then. If you really don't know, then you just sort of maddeningly ask basic questions until the other side spells it out very clearly. Because
Once the commission dispute resolution, the money was taken away, doesn't exist anymore. There's really only one spokesperson organization regarding ADR, and that's the Supreme Court of Ohio, which serves attorneys. There is no voice. So let's say something gets proposed in the legislature regarding mediation. XYZ will be true of mediation. The mediators will be fill in the blank. OMA goes to testify, and the state representative from Cuyahoga County says, what does Mano have to say about this? And we sit there with that kind of face, or vice versa. Should the day come that the legislature wants to do something about our profession, we need to be able to speak with one voice. They can in Wisconsin, they can in Pennsylvania, I think in Michigan. There's several places where they have one voice. I'm not in any way saying Mano should go away. I'm saying we should have some way of being linked and connected so that we have one voice. Because it could happen tomorrow. Someday somebody might put something in front of the state legislature, and I think when that happens,
Was do a feasibility study on a national credentialing for mediation. And they did a lot of work in trying to figure out how could they develop a curriculum or a program so that all mediators, they could be standardized all over the country in terms of being a credentialed mediator. And they realized it was not feasible. And therefore, after much ado, they realized that everybody does have to do it on each state is going to have to do it all on their own. But what was really cool is that they did this the American Bar Association had a specific task force on, well, we cannot do anything to credential people on a standardized national basis, but what we can do is look at what are ways of being able to improve the quality of mediation so that everybody from whatever state or whatever community will be able to improve it. And so what they did is develop a task force that went through 9 different states, and they did a whole series of interviewing and survey questions and all kinds of things. And they used, not only did they talk to mediators and the lawyers who accompany their parties, there are a lot of situations where they have the lawyers. So they had those lawyers who go to the mediations, and then they had the users, the end users, take a look at what worked for them and what didn't work for them. Because a lot of the HR people go to a lot of them. I mean, a lot of the people who are in certain industries will do that. So they took a look at these kinds of things, and EJ broke it down for us for today to take a look at some of the results that they came up with, and then for us to take a look and see what kinds of things that we could I guess from here, what it would be, how we would be able to develop at some point best practices and things like that.
Exactly. And yeah, they, I think there's a 49 page, might be a little bit longer, so I didn't